Hello, today I'm going to talk about Chapter 9, Negligence, Strict Liability, and Products Liability. What is negligence? Negligence is the unintentional tort. What is a tort? A tort is a harm which is recoverable under civil law. So there are intentional torts like civil assault, battery, false imprisonment, and then there's civil unintentional tort, an example of which is negligence. To win a negligence case, the plaintiff must prove that the defendant failed in 4 elements: duty, breach, causation, and harm or damages. So the first, duty, there must be a duty of care owed to the plaintiff, and the defendant would have breached that duty of care. Breach, a duty must be breached, falling below the standard of care owed. Then causation, there's factual cause and legal cause. And factual cause, the injury must have been the cause, in fact, of the plaintiff's injuries. And the proximate cause, it must have been the foreseeable cause that the defendant would have caused that type of harm to the plaintiff. So factual cause, the injury must have been caused by the defendant's actions, and proximate cause, that it must have been foreseeable that the action would cause this kind of harm. And damages or harm, the plaintiff must have been hurt in some way, whether physically, monetarily, in order to recover for a negligence cause of action. Examples of negligence types of cases are car accidents, trip and falls, medical malpractice, just to name a few. So first let's talk about duty. If a defendant could have foreseen injury to a particular person, he or she has a duty to them. In some states, a social host serving alcohol to an adult may be found liable for harm done by the person drinking the alcohol. Many states have a DRAM Act, making liquor stores or bars or restaurants liable for serving drinks to intoxicated customers, which later cause harm. And there are special rules for liability of landowners. So let's talk about some special duties that landowners owe, because they're talked about in the text. So what is a duty owed? What is the duty owed by a landowner, right? The owner of a property, your home, your property. What duty do you owe to trespassing adults? Well, the standard is to not to injure anybody intentionally. What duty is owed by a landowner to trespassing children? And the rule states that if a man-made item on the land attracts children, the landowner might be liable. And that's the theory of attractive nuisance, right? That's why the law requires homeowners who have a pool to have their pool fenced in, right? To protect those trespassing children from drowning in your pool. Okay, licensees, the landowner has a duty to warn of known but hidden dangerous conditions that licensees are unlikely to discover for themselves. What's an example of a licensee? Someone who, say for example, buys a ticket to a concert, right? If you're a ticket holder, you're considered a licensee. So if you bought a ticket to a concert and you looked on the back, it would say this is a license for you to enter the property to see the concert, and then when the concert is over, you need to leave, and you are no longer a licensee. So what's the duty to licensee? To warn of known but hidden dangerous conditions that the licensees are unlikely to discover for themselves. And invitees, right, someone you invite on your property, the standard duty owed is to exercise reasonable care to protect invitees against dangerous conditions that the possessor of the property should have known, that the possessor should know of, but invitees are unlikely to discover. okay, and special duties owed by professionals. While on the job, a person at work must act as a reasonably prudent person in their profession. So, a reasonably prudent orthopedic surgeon has a duty, an orthopedic surgeon has a duty to practice as a reasonably prudent orthopedic surgeon in their profession, just as an example. Breach. So the first element was duty. We talked about duties. Now we'll move on to breach. A defendant breaches his or her duty of care by failing to behave the way a reasonably prudent person would under the circumstances. So it's a reasonable person standard. The next element is causation, and there are two types of causation that need to be proven, two elements of causation: factual cause and proximate cause. So, factual cause: if the defendant's breach ultimately led to the injury, he is liable. It does not have to be the immediate cause of injury, but it must be the first in a direct line. Proximate cause: to be liable, this type of harm must have been foreseeable. Okay? The defendant does not have to know exactly what would happen, just the type of event that would occur. Okay? And in the PowerPoint, I want you to look at the slide, which is the example of factual cause and proximate cause. And we'll give this car accident example, and I'll discuss it now briefly, but I want you to go back and look at the slide, which is the chart or example of factual and proximate cause. So here's my example. If I bring my car to my auto mechanic because my brakes aren't working properly, okay, and I want the auto mechanic to fix the brakes, okay, the mechanic fails to fix my brakes, right? He tells me he fixes them. I go to pull off out of the parking lot, and I'm in a car accident and I hit a bicyclist. The mechanic is liable for the bicyclist, right? Because they failed to properly fix the brakes when I brought it to that professional, and I expected them to be fixed because they told me they were. That is the factual and foreseeable, proximate, legal cause of the injury. Mechanic fails to fix the customer's brakes, which causes the car accident, causes me to hit the bicyclist, and the mechanic is liable to the cyclist because they failed to fix the brakes properly. Okay, the next scenario is the car accident. There is a car accident pulling out from the parking lot of my mechanic, and I hit a bicyclist, right? And say the noise from the accident startles somebody who falls out a window in a nearby apartment house. Is the mechanic liable for the person falling out the window? No. It might be the factual cause, but if there's no foreseeability, it's not foreseeable that somebody would fall out a window because I hit somebody on a bicycle because my mechanic failed to fix my brakes. Okay, so, and the third scenario is I'm driving out of the parking lot and I do not hit a bicyclist, but I'm driving along out of the parking lot. There's a bicyclist coming. He hits a pothole and crashes. Is the mechanic liable? No, because there's no factual or legal cause on the part of the mechanic that causes the bicyclist to hit a pothole and crash. Okay, so that's factual and proximate cause in a nutshell. Damages. So that's the fourth element in proving a negligence cause of action: duty, breach, causation, factual and proximate cause, and damages or harm. So injury: the plaintiff must show a genuine injury. They can prove future injury, and they may be compensated for that with money damages, but it has to be determined at the time of trial. Okay, once a negligence cause of action is heard in court and a trial takes place and a verdict is rendered and a jury awards a person damages, the plaintiff damages for a negligence cause of action, the plaintiff can't come back again to claim more damages in the future. Therefore, the plaintiff would have to prove all their current and future damages at the time of trial. So say, for example, I'm in an accident, somebody hits my car from behind and I hurt my neck, and I incur medical expenses, I incur permanent damage, I can't work anymore, so I lose income. I need to prove all my current and future damages at the time of trial. I need to present to the jury. So I would submit medical records, loss of income records. But if I'm going to need surgery 10 years from now, I'm going to need to prove that I will need money for that 10 years from now. So I would have an expert doctor come in as a witness to testify about my future damages. Okay, so damages are usually compensatory damages designed to restore what was lost, and in some cases there might also be punitive damages, and we'll discuss a whole chapter on damages towards the end of this course. But the point is that damages must be proven in order to recover, and it's usually money damages, right? Because even though they can't make my neck whole again, right, I can't get a new neck, but I can be compensated because that's the next best thing, money, to help me to restore what was lost is really the only thing I can recover. Assumption of risk is a person who voluntarily enters a situation that has an obvious danger cannot complain if they are injured. They've assumed the risk, and this rule applies to situations where the danger is well known and the participant chooses to be present. So what would be unusually dangerous activities you might engage in and assume the risk of injury? Hang gliding, parachuting, those are types of dangerous activities where that might be used as a defense by the defendant that you've assumed the risk of danger. Strict liability. Some activities are so dangerous that the law imposes a high burden of proof, such a high burden on them. This is called strict liability. Defective products may incur strict liability. So this involves ultra-hazardous activity. Defendants are virtually always held liable for harm. And what are examples of ultra-hazard activities? These include harmful chemicals, explosives, keeping wild animals. The plaintiff doesn't have to prove a breach of duty or foreseeable harm. They just need to prove causation and harm, right? Because it's obvious if you have a wild lion on your property and you invite company onto your property, right? And that lion mauls somebody, right? You don't have to prove duty and causation. That's an ultra hazardous activity, keeping that wild animal. So the plaintiff would only need to prove causation and harm, that lion caused the plaintiff's harms. Products liability. When goods cause injury, there's a question of products liability. There are two main issues related to products liability cases: negligence, which is unreasonable conduct by the defendant, and strict liability, which is a policy which holds the defendant liable regardless of their behavior. Negligence. In negligence cases, plaintiffs most often raise one or more of these claims: negligent design, negligent manufacture, failure to warn. So say the manufacturer puts a dangerous children's toy, right, on the market, and the plaintiff wants to sue the defendant, the toy manufacturer. They can sue under negligence or strict products liability, right? Negligent design, negligent manufacture, or failure to warn of the dangerous condition. And where a sales contract includes proper disclaimers or remedy limitations, a buyer may be barred from a negligence case and have no remedy. Strict liability for defective products. The plaintiff need not prove that the defendant's conduct was unreasonable. In strict liability, they need to show, first, that the defective condition is unreasonably dangerous to the user. 2, the seller is in the business of selling this product. 3, the product reaches the user without any substantial change. Strict liability may be imposed even if the seller exercised all reasonable care and there is no contractual relationship. Okay, so that's my summary of Chapter 9. Feel free to email me if you have any questions.